Lawyers representing Nandipha Magudumana have rubbished claims made in a responding affidavit by the Department of Home Affairs and the South African Police Services that she was deported and not extradited from Tanzania. The lawyers argue that the facts point to an act of extradition. Magudumana wants her arrest declared unlawful. She faces a litany of charges linked to her partner Thabo Bester's dramatic jailbreak last year.
And then we said extradition involves basically three elements. Acts of sovereignty on the part of two states. Two states, we emphasize two states. A request by one to another state for the delivery, and the delivery of the person concerned for trial or sentence in the territory of the requesting state. And then that's extradition. Three elements. Then it tells you, the court tells the world, deportation is essentially a unilateral act of the deporting state in order to get rid of an undesired alien. The purpose of deportation is achieved when such alien leaves the deporting state's territory. Importantly, my lord, the destination of the deportee is irrelevant for the purpose of deportation. The facts here demonstrate clearly on any version this was extradition. That's it. That's our case. I could actually sit down now, but I'll need to drill down to the facts.
Okay, joining us to help us make sense of all of this is Gary Eisenberg, attorney and director at Eisenberg and Associates. Gary, thank you very much for your time this afternoon. So, as her lawyers argue that this indeed was an extradition, we heard from Advocate Neil Snellenberg on behalf of the South African Police Services and the Director of Public Prosecutions, arguing essentially that the case has been shown to be utterly untruthful. He says, after reading the founding affidavit of how Magudumana was arrested in Tanzania, she has not informed the court of the relevant circumstances, and she and Bester were arrested by Tanzanian officials because she was in that country illegally. What to make of all of this?
I think if you come through all that noise without myself having any skin in the game, I don't represent any of these parties, and I've read all the papers of the respondents and of Dr. Nandipha. And my view remains the same as it's been throughout. Whether you call it an abduction, as she has in her founding affidavit, on the basis of what she thought had happened to her in Tanzania, or you call it a disguised extradition, that's what it was. It was trying to get her back through the back door. And as counsel for Dr. Nandipha very ably demonstrated, deportation is a unilateral act, and the destination country doesn't make any difference. And that is what the Constitutional Court said more than 2 decades ago in the Mohammed case. So we have a situation where the respondents, the government of South Africa, says in terms, we had her deported from Tanzania, wherever the arrest, however the arrest might have taken place there. And these were not the facts which supported a deportation. Deportation by any means, under the circumstances, was a violation of South African constitutional law and a violation of international law and a violation of the treaty of the SADC extradition protocol in existence between Tanzania and South Africa. And that is Dr. Nandipha's case. And the respondents do nothing to contradict that. So I believe Dr. Nandipha has a seriously good case, and we wait to see how the judge will decide it.
Because the advocate for the respondent, Advocate Neil Snellenberg, is arguing that, well, she was never arrested or handcuffed by the South African Police Services. There's no foundation for the criticism that is leveled against the police that they did that. In fact, going as far as saying that, well, she hitched a ride to come back to South Africa because she told all and sundry who were within hearing shot that she wanted to come back home to South Africa because she is a mother. She wanted to attend to her children. Does that argument not hold?
Well, I'm not the judge of who's right as a matter of fact. But it does appear to me on the papers made by the affidavits made by the state, by the Department of Home Affairs, by the police, and so on, that it was a deportation. They went to Tanzania and they collected her from Tanzania as a consequence of the collusion between the South African and Tanzanian governments. That's all I need to know to understand that how she got to South Africa was unlawful. It should have been an extradition hearing. It should have been an extradition inquiry. There should have been an extradition request made by the Republic of South Africa to Tanzania. Unfortunately, what the state maintains is that they had to receive the permission of the Tanzanian government to extradite before that process would ensue. There's no such process in the world where you ask the requested state for its permission to be able to extradite. That doesn't happen. So as I say, on the papers, no matter what was argued by the state's legal representative, I am satisfied what I've maintained throughout, that Dr. Nandipha was brought to South Africa by disguised extradition unlawfully, and that the court in South Africa, the magistrate's court, is no extradition to try her. That's been my position. I've read the papers. I'm still of the same view.
Sure. So essentially you're arguing that she could possibly win this case, but we heard from the defense lawyer arguing on behalf of the state and the South African police services that, well, she wants to get away on a technicality, and there is no technicality here. He argues that the circumstances in which she was brought into South Africa cannot be altered. She cannot go back to Tanzania as she is prohibited there, and the manner in which she was arrested will not prejudice the trial. More interested in the manner in which the applicant was arrested will not prejudice the trial. So even with that argument, we should still understand this as her potentially winning this round?
Again, I'm not the judicial officer and I don't want to pretend to be, but jurisdiction of the South African court is everything here. And if she was brought unlawfully before the court in South African law, the court has no jurisdiction in respect to trying her on these charges. That's how I see it. And I don't see any other fair result except a discharge by the magistrate's court as a consequence. If they don't have jurisdiction, they can't try her. And that's all there is to it. And nobody's suggesting for one moment that they send her back to Tanzania so that they can start this process all over again, but this time properly. No one is suggesting that. That would be an absurdity. So let's see. I think we need to be a little bit patient. It's quite complex. Different parties have different versions of facts, even amongst different respondents, representing different facets of the South African government, the police, Director of National Public Prosecutions, the Department of Home Affairs. Everybody seems to have a different factual version. Let's see what the judge does, and we need to be patient for the outcome.
Indeed. In fact, we're going to be hearing from the lawyers arguing on behalf of the Department of Home Affairs come 2 p.m. Gary, thank you for your time this afternoon. Gary Eisenberg is an attorney and director at Eisenberg and Associates.